In the practice of civil engineering, it is important to satisfactorily meet the expectations of both the client or employer and the requirement of the project. Today, the first group of reporters from BSCE-3B will introduce to us the key points we need to know as future civil engineers. First topic is the professional responsibility, which will be discussed by Jain Azalatutubo. Secondly is the discussion about client-civil engineer relationship to be tackled by Francine Ann Alegre. Next to that is another key point known as prime professional practice, and its discussant is Kimberly Arreglo. The fourth discussion includes the employment and design competition with Philip Fernando Basilan as the reporter. Following is the topic about contingency basis of employment with words from Abigail Belga. Lastly is about professional practice of foreign civil engineers to be presented by Babelin Bo. On behalf of the group, I would like to encourage everyone to please stay still so that we could advance our knowledge with regards to the practice of civil engineering.
Hello, in this video, our group will discuss about the practice of civil engineering. I am Jain Ezel and I will be your discussant for the first topic, professional responsibilities. Discussing the professional responsibilities of a civil engineer, we will also go through its roles. The work of a civil engineer is all around us, yet many do not realize what a civil engineer is responsible for doing. So it is very important to first provide a formal definition highlighting the roles of a civil engineer. So here is a definition from Wikipedia. A civil engineer is a person who practices civil engineering. This includes the application of planning, designing, constructing, maintaining, and operating infrastructure while protecting the public and environmental health, as well as improving existing infrastructure that may have been neglected. So civil engineering incorporates a broad range of different job roles and responsibilities. They work in many areas including research, design, construction, and education. Civil engineers are responsible for the design, supervision, building, maintenance, and operation of construction systems and projects in both private and public sectors. Projects they work on include construction of highways, dams, roads, tunnels, airports, bridges, water supply and treatment systems, and other smaller facilities. So the role of the civil engineer and also its responsibility is very vast. The standard of practice is for civil engineers to be given responsibility for studying, conceiving, designing, observing construction, and assisting in programming for operating and maintaining engineering works. So isa-isahin natin. First is studying. Studying. We all know that civil engineering is a novel profession, and having this noble profession entails proper and formal education. As civil engineering students, it is a responsibility to study and equip ourselves with knowledge. Pero ang developmental years ng isang civil engineer does not end when he or she graduates. It does not end after the completion of the civil engineering course. It is actually a continuous studying and learning process. Kasi even out there sa field, they still study. Kasi for example, a civil engineer is given a proposed site location. The civil engineer still studies. Pinag-aaralan niya yung area, yung lupa, kung anong type ng soil, and even sa other fields. Pinag-aaralan nila yung materials, ganon. Again, studying is a responsibility not just for an aspiring civil engineer student, but also to a licensed civil engineer because it equips us with the knowledge and civil engineering principles. Conceiving. Conceiving means coming up with an idea or forming a concept. It is more about having analysis. It is a responsibility for civil engineers to have a broad understanding regarding the matter in their field. In this type of work, civil engineers perform analysis in a very important manner since it is also a very important component. So civil engineers are required to perform a thorough and detailed analysis of the structure with respect to the principles of the structural designs. So this help ensures that the new structure meets up all the necessary safety criteria and design codes. So hindi lang about sa problem solving, though students pa lang tayo, sinasabi na important yung analysis, lalo na sa field ng civil engineering. Thus, analysis is really a key part in this type of job, the civil engineering. Next is observing construction. So, a civil engineer's work is before the project, during, and after. So, itong observing construction happens during. So, a civil engineer oversees various construction efforts and different areas of this field. Next is assisting in programs for operating and maintaining engineering works. So, dito involve yung operation and maintenance of any civil engineering task. Last is other services. Of course, list goes on sa task ng isang civil engineer and responsibilities. So, when the call arises during the evolution of the project, dapat i-fulfill yun ng isang civil engineer. So, those are the general responsibilities of a civil engineer, and here are some of the specific duties of a civil engineer. First, civil engineers shall conduct themselves in a highly professional manner and serve as faithful trustees or agents of their clients or employers. So, if given the project, syempre, yung boss natin is yung ating mga kliyente. So, we should conduct ourselves in a highly professional manner. How? There must be no grounds for overfamiliarity, and dapat i-meet natin yung expectations ng ating employer at the same time meeting the requirements of the project. Next, civil engineers are therefore bound by the fundamental canons of ethics contained in this manual. So, we have discussed about the 4 fundamental principles and the 7 fundamental canons. So, dapat iyong i-follow ng isang civil engineer at mag-manifest yun sa isang civil engineer. Next is care and protection of the environment is paramount in the civil engineer's work engagement. So, civil engineers, even though karamihan ng kanilang work engagement is for man-made structures, dapat ay pro-environment pa din. They still need to play an important role in the environmental protection. Civil engineers are required to protect our environment in terms of inventing safe elemental substances, sustainable environment, and recyclable and renewable energy resources, and so on to ensure a better life for the next generations. So, dapat, even though man-made, it shall promote a pro-environment thing. Last, civil engineers must always strive to maintain the highest standard of ethical professional practice in their dealing with client, employers, employees, competitors, and the community. So, pansinin natin na hindi lang dapat sa ating mga kliyente yung ating pakikipagtungo ng maayos. So, dapat i-acknowledge din natin ng ating competitors as well as the community. So, handling professional matters in a professional way. That is how a civil engineer should go and do. So this is another important reason for a civil engineer to have the code of ethics, because it is for professional engineers to set a standard for professional behavior.
Client-civil engineer relationships. Many engineering works are conceived, designed, and constructed through the efforts of civil engineers employed in governmental agencies or in industries. Other engineering projects come to fruition through the efforts of civil engineering firms engaged for a specific project or program by public agencies or private clients. Many public and private entities of necessity rely on civil engineering as their employees. Independent civil engineering firms are also relied upon to accomplish projects which required special expertise beyond the normal capabilities of the client. More recently, clients have been utilizing new concepts such as program management and design build to implement projects. So, in here, na maraming public and private individuals ang nagre-rely sa mga civil engineering. So, since civil engineers, since nakikita naman sa kanilang performance that they are putting efforts on their work, and whether they are from governmental agencies, industries, or from engineering firms. Definition and explanation of proper relationships between civil engineers and their public and private clients are important objectives of this manual. These are discussed below. Obligations of the civil engineer. The obligation of the civil engineer includes number 1. The civil engineer shall perform scope of the services as stated in section 2. Since yung scope of the services is in section 2 or the next chapter or topic which will be reported by the next reporters. And number 2, the civil engineer shall exercise reasonable skill, care, and diligence in the performance of his obligations. Number 3, the civil engineer shall act independently and, as required by the contract, perform with the necessary skills and professional judgment when required to certify, decide, or exercise discretion between the client and a third party with whom the client has a contract. So, sa number 2 and 3, of course, as a civil engineer, dapat pinapakita natin ang ating necessary skills and ang ating diligence in the performance of our work. Dapat pinapakita natin ang professionalism natin when it comes to work. And next, number 4, the civil engineer is authorized to act as the client's faithful agent when required, but only as implied in section 2 or implied in the contract adopted for the project. So in number 4, it means na when it comes to work, the civil engineer is authorized to be devoted or reliable to the client, but of course within the suggested services na mahahanap in section 2 and or from the contract na adopted for the project. Number 5, when aware of any matter which will change or has changed the scope of services, the civil engineer shall give written notice to the client containing particulars of the change. For specified stages services, the civil engineer shall not initiate or proceed with any subsequent stages of the services without the approval of the client. So in number 5 and 6, if the civil engineer is aware na magkakaroon or nagkaroon ng changes sa scope of the services, dapat, of course, mag-give siya ng written notice sa kanyang client about it. So, next is number 7. When required, the civil engineer shall direct and cooperate with all other professionals and integrate their work where applicable into that being undertaken by the civil engineer and other professionals, but shall not be professionally liable for their work. So the civil engineers can, of course, cooperate with other professionals and pwede silang mag-coordinate ng kanilang work, but of course the civil engineer shall not be professionally liable for other people's work since there are other professionals na involved. Next is number 8. The civil engineer may recommend specialist suppliers or contractors to design and execute certain parts of the work, in which case the civil engineer shall coordinate the design of such part or parts with the overall design of the work, but he shall be relieved of all responsibilities for the design, manufacture, installation, and performance of any such part or parts of the works. The civil engineer shall not be liable for act of negligence, default, or omission by such person or persons. Since sa number 8, pwedeng mag-recommend yung civil engineer ng mga specialist supplier or contractors to help with the design and execute certain parts of the work. Of course, at the same time, dapat the civil engineer shall coordinate. But, of course, since may nirecommend na ibang suppliers or contractors, of course, the civil engineer shall be reassured of the responsibility for the design and installations, and of course should not be responsible for the acts if ever na magkaroon na ng carelessness or omission na gawin ng ibang people na involved sa work. Next is number 9. The civil engineer shall notify the client of any interest the civil engineer has which may significantly conflict with the interest of the client under their contract. Of course, since ang engineer, if ever na magkaroon daw siya ng interest na maaaring makakos ng conflict sa interest ng kanyang client under their contract, of course, the civil engineer should notify the client. Next is the obligations of the client. Since merong obligations ang civil engineer, dapat meron ring obligations ang client. The client has the following obligations. Number 1, the client shall pay the civil engineer for his services the amount of fees and expenses set out in or determined in their agreement. Number 2, the client shall provide the civil engineer within reasonable time that does not result in delay to the provisions of the services all information required by the civil engineer in the performance of his services and a decision in writing on all matters properly referred to the client in writing. In number 1 and 2, it means, of course, since nag-hire ng civil engineer ang client, dapat ang services na ginigive ng civil engineer is bayaran ng tamang amount or kung ano ang pinapag-usapan sa kanilang agreement. And the client dapat mag-provide rin ng reasonable time for the engineer, and of course, all the information na required by the civil engineer dapat binibigay na rin. Next, number 3, the client shall cooperate with the civil engineer and shall not interfere with or obstruct the proper performance of the services. Sa number 3, since ang client nag-hire, dapat makipag-coordinate rin ito sa civil engineer, and at the same time, dapat hindi rin nakaka-interfere sa performance ng civil engineer. Number 4, the client shall, as soon as practicable, make arrangements to enable the civil engineer to enter the site and inspect facilities needed in the performance of his services. Number 5, the client shall arrange for the provision of services from other professionals or others as may be required and bear all the costs. Sa number 4 and 5, the client of course should allow the civil engineer para i-inspect ang site and i-perform ang kanyang mga services, and also make use of the services from other professionals and should bear all the costs. Number 6, when the civil engineer is required to administer the work of other professionals or other third parties who are directly contracted by the client, or when the civil engineer is required to act as engineer to the contract of any contract on behalf of the client, then all instructions by the client shall be given through the civil engineer. There are times that it means that there are times na ang civil engineer is required or ma-authorized by the client para i-supervise ang mga work of other professionals. So, dapat the client, of course, should give proper instructions sa civil engineer. And number 7, when aware of any matter which will change or has changed the scope of the civil engineer's services, the client shall notify in writing within 7 days the civil engineer containing as far as is practicable the particulars of the change. Of course, just like the civil engineer, if aware ang client na magkakaroon or nagkaroon ng changes sa services ng civil engineer, dapat i-notify niya rin ito. Next is the liability of the civil engineer and the client. The civil engineer shall only be liable to pay damages to the client arising out of or in connection with their agreement if a breach of duty or care is established against the civil engineer. The client shall only be liable to pay damages to the civil engineer if a breach of the Resolution of any conflict arising from the agreement between the civil engineer and the client shall be done by giving preference to the process of arbitration. Establishment of the breach of duty on the part of the civil engineer and that of the breach of the client's duty to the civil engineer shall be undertaken by a third-party arbitrator mutually acceptable to the client and the civil engineer. So, it means if ever na magkaroon ng conflict, an arbitration will take place. An arbitration is a private process or a way para ma-resolve ang conflict outside the court and will be decided by several individuals that is acceptable naman to the client and the civil engineer and that several individual will be the ones to parang decide after hearing the evidence or the arguments of both parties. Next is limitation or civil engineer's responsibility. Number 1. The civil engineer shall have no responsibility or liability for cost, loss, or damage of whatsoever nature arising from any errors in or omission from data, document, plans, design, or specifications not prepared by the civil engineer or other personnel under the direct control of the civil engineer, and arising from any act or omission or lack of performance or any negligent of or fraudulent act or omissions by the client or any other consultant, contractor, or supplier to the client or any employee or agent of the client, other consultants, contractors, or suppliers. In number 1, it means that the civil engineer is hindi responsible for any loss or damages na from data, plans, designs na hindi prepared ng civil engineer or ng mga personnel na under sa kanya. And number 2, notwithstanding any recommendation or lack of any recommendation made by the civil engineer to the client, the civil engineer shall not be held to have any warranty or promise as to the suitability, competence, or performance of any other consultant, contractor, supplier, or other third party. Number 2, in spite of any recommendation or lack of recommendation made by the civil engineer will not be held as kumbaga responsible for the performance of others. And number 3, the civil engineer shall not be responsible for the techniques, methods, programs, sequences, or procedures adopted by any contractors or other third party responsible for executing any aspect of the project, nor for their performance on time, their failure to carry out the work in accordance with any contract, documents, or for any other act of omissions. So, the civil engineer daw hindi magiging responsible if whatsoever techniques, method, procedures, and other things na gawin ng iba. Next is damages. If found that the civil engineer undertaking services is liable to the client, damages shall be payable on the following terms. Number 1. Damages payable shall be limited to the amount of reasonably foreseeable loss and damage suffered as a direct result of such breach. Number 2. The maximum amount of damages payable in respect of liability, whether under the law or contract or otherwise, is limited to the amount specified in the specific provision, or if no such amount of provision is specified, to the lesser of 300,000 or 10% of the total amount of damages of the portion of the work attributable to the civil engineer's breach of duty, or 25% of the total of fees payable under their agreement. Number 3. If found to be liable in circumstances where the act or omissions of a third party have contributed to the loss or damages, the proportion of damages payable by the party found liable shall be limited to that proportion which is attributable to the party's breach of duty, whether the claims are made under contract or otherwise. So, when it comes to damages, dapat ang amount na babayaran is nakabase from the foreseeable loss and damages suffered, and depending sa amount, dapat it should not less be than 300,000 or should be 10% of the total amount of damages or 25% of the total of fees payable under sa kanilang agreement. And there are also times na nagiging involved din ang other parties dito, nagiging liable rin sila sa if ever na may magawang mangyaring damages. Dapat mag-share rin sila ng, of course, ng amount na money na ipipay. Next is the suspension or termination of services. If circumstances arise for which the civil engineer is not responsible and which makes it impractical or impossible for the civil engineer to perform in whole or in part the services in accordance with the agreement, then the civil engineer shall not promptly notify the client of the same. There are times or cases na nagiging impossible for the civil engineer to finish the project, and if magkaroon ng suspension, therefore, dapat i-extend ang contract. Next is, if by reason of the above-mentioned circumstances, certain services has been suspended, the time for their completion shall be extended by the extent of the delay plus a reasonable period for their resumption, or if the speed of performing certain services has to be reduced, the time for their completion shall be extended as is necessary by reason of the circumstances. The client may suspend all or part of the services or terminate the agreement by written notice of not less than 30 days to the civil engineer, who shall immediately make arrangements to stop the services and minimize further expenditure. Of course, pwede rin ang client ang mag-suspend ng project, but dapat may notice within 30 days sa civil engineer. The civil engineer, by written notice of no less than 30 days, may terminate the agreement or at his and or her discretion without prejudice to the right to terminate, suspend the performance of the whole or part of the services under the following conditions. So, the civil engineer can terminate rin the contract, of course, within written notice, no less than 30 days, pag di na-meet ang mga following conditions. Number 1, when the 30 days after the due date or payment of any account, the civil engineer has not received payment of that part of it which has not by that time been contested in writing, or number 2, when the services has been suspended for a period exceeding 6 calendar months, or if it is clear to the civil engineer that it will be impossible or impractical to resume the suspended services before the period of suspension has been exceeded 6 months. So, sa number 1, it means parang walang natanggap na payment within the time na napag-usapan. And the second one, if ang suspension nag-surpass sa 6 months. When the services are suspended or terminated, the civil engineer shall be entitled to payment for the services carried out, including consequential costs, expenses, disruption fees incurred as a result of the suspension or termination, and remobilization fees on resumption. Suspension or termination of the agreement shall not be prejudiced or affect accrued rights or claims and liabilities of the party, which means nag-suspend or nag-terminate, whether nag-suspend or nag-terminate, dapat magkaroon or makareceive pa rin ng payment. Next is settlement of disputes. If a dispute arises on either party, then the party shall by notice in writing serve on the other party of the details of the dispute, and request that the dispute be resolved by conciliation. If the matter in dispute is not resolved in conciliation, between the parties within the prescribed time, then the matter in dispute shall be referred to arbitration. If sabi dito, ever na merong if ever na merong magkaroon ng disagreement from both parties, then both of them shall give a written notice about the details of the disagreement, and of course mag-request that it be resolved by conciliation. And if ever na hindi madaan sa conciliation within the determined time, then dito na papasok ang arbitration. Lastly, ownership of data, designs, and documents. The design analysis, drawings, specifications, and reproductions thereof are instruments of services owned by the professional engineer and shall be used only for the specific project covered by the agreement between the client and engineer. So, parang ang example dito, or it means na since ang engineer ang nag-design or nagawa ng blueprint ng bahay, ito ay bawal ito gamitin without the consent of the civil engineer. That's all. Thank you.
Prime professional practice refers to the engagement of engineering services where consulting civil engineers serves the client directly as prime professionals. So we all know that the consulting engineer is different from the engineer that will do the project. Consulting engineer is the one to be consulted by the engineer that will do the project regarding the planning, the modification, or the rehabilitation of the structure. Most of the time, civil engineers do a project for other people, but in prime professional practice, a civil engineers do a project of his or her own since he's the owner of the project. At the same time, he will engineer the project. So there are instances that a civil engineer serves the client indirectly as a sub-consultant to an engineer or an architect responsible to the project, or the ones considered as the prime professional of the project. So these services may also be performed through another entity on design, build, construction management, or turnkey project.
Hello everyone, my name is Philip Basilin and I'm here to discuss about employment and design competition. Civil engineers are employed by professional consulting firms, government agencies, educational institutions, construction firms, manufacturing and commercial entities, and other entities. Engineers are hired by said parties for either consultation, supervision, or to take on a project. In the course of these transactions, they are asked sometimes to sign a contract. Here in this report, I will try to discuss a little bit about how we are bounded by said contracts. For example, how we are protected and held responsible by signing a contract. In the Civil Code of the Philippines, these are tackled in depth. We are going to cite a few examples in order to get more insight regarding the topic. Under Title 8 Lease, Section 2 Contract of Labor discusses the basic obligations of being in a contract. Like for example, health and safety should not be jeopardized, and no contract shall be forcibly enforced on someone, or applications shall be always voluntary, and labor shall be paid in legal currency, and their wages should not be withheld by any means unless for due debt, and employers are not allowed to confiscate or seize tools belonging to the laborers and employees. Dismissals are also subject to supervisions of governments. In Article 1711 and 1712 tackles more about death and injuries in case of these mishaps happening. During these mishaps, employers and enterprises are obliged to pay compensations for the victims, but only under strict conditions. Like for example, if the injury or death occurred, like for example, when an employee happens to catch an illness or got sick because of the job or the nature of the job, the employer is held responsible and must compensate because because they are liable. But in case of the employee getting injured or dying because of their own carelessness or negligence, then the employers are not personally liable. However, if there happens to be fault in both parties, both the employees and the employers, then the employers are held liable, but their compensations are equitably reduced. Now, in case of death and injury occurring when from between fellow workers to another fellow worker, then employers are held liable only if it happens under their supervision and they could have prevented the event from happening. But in case that the accident happened due to a malicious act or it was intentional, then the employers are not answerable to the incident. Moving on to Section 3, Contract for a Piece of Work tackles more about the responsibility of the engineer, architect, and contractor for the project. Like for example, if you promised to build a house of a certain quality, then you have to deliver and build that house of that same quality. Or for example, in the employer's side, if the work cannot be done because of the defect in the material furnished by the employer, or perhaps it was ordered by the employer, then the contractor has the right for compensation and reimbursement for the expenses for that amount of time. And also, engineers and architects who designed the specification for a building are held liable for the damages within 15 years of completion of the structure. Say if anything happens with that structure, say it collapsed, they are held liable along with the contractors. Other examples are if the contractor and the supervisors are responsible for the work done by the persons they have employed. And like mentioned in Section 2, the contractor is liable for all the claims of laborers and other employed by him and of third person for death or physical injuries during that construction. Also, in Article 1731, he who has executed work upon a movable has a right to retain by way of pledge until he is paid. I cannot explain. I don't have a firm understanding about this. But if a project is say completed, but the payment isn't, then that the contractor has the right for that project until he's paid his due. Design competition is a process through which civil engineers is selected above other competitors based on a proposal or an innovative approach to solving a client's need. Competing firms are normally shortlisted from a number of engineers responding to a client's solicitation either directly by a letter or indirectly through a newspaper or other forms of publication. The civil engineer should be awarded a stipend to participate in the competition. As mentioned, this is where a client solicits a design proposal from a professional or solicits a solution from a professional. I believe this is how a bidding starts, wherein clients who has a plan to start a particular project would invite via directly or indirectly firms, contractors, or engineers, and whoever has the best price and proposal will be awarded the project.
Contingency basis of employment. Canon 5C, or the PIE's Code of Ethics, provides that engineers may request, propose, or accept professional commissions on a contingency basis only under circumstances in which their professional judgments would not be compromised. What is meant here by professional commissions on a contingency basis, or the contingent commission, is the commission paid to the engineers in certain conditions. For example, a client wants to build a dam and the engineer was tasked to make a design, but the payment for his or her service would be contingent on the client's ability to receive a construction bid that was under the budgeted amount. If the engineer's design was such that all construction bids were over the budgeted amount, then he or she would be required to redesign the project at no additional cost to the client. If after the redesign, the client was still unable to solicit a construction bid within its budget, the engineer would receive no payment at all. So, ang meaning dito ng contingency basis of employment is that engineers may accept this kind of agreement as long as hindi mako-compromise yung professional judgment nila. Otherwise, unethical na yun. For example, the BERK 65-4, wherein the engineer is requested to perform a feasibility study for a client, and the engineer's fee is contingent upon the result that the study will recommend that the project go forward. So, in this case, according to the Board of Ethical Review cases, it would be extremely difficult to disagree that such a contingency may have the effect of compromising the professional judgment of the engineer performing the feasibility study. Kasi, pwede siyang matempt na ibahin yung result para maging favorable sa kanyang situation. Kaya, although contingent commissions are permissible, it is the general view of PIES that it is not in the best interest of the client or the public for the civil engineer to provide professional services on a contingency basis. That's all. Thank you.
3 years ago, when I was just about to enter college, I wasn't sure yet of what path would I take. However, I am certain of one thing. I am sure that I would be working abroad, whatever job I would land on to after college, and this is the typical mindset of several Filipinos. I am not currently wild guessing because according to statistics, 52.9% of Philippine youth aged 15 to 35 years old would like to work abroad for some reason, and probably first on the list, admit it or not, is the difference in salary. Part of the population of OFWs are professionals such as teachers, nurses, and even engineers. Yes, they contribute to the development of the Philippines, but who else will work for the construction projects within the country if all civil engineers will work overseas? As we notice, one of the focuses of the Philippine government are infrastructure projects. That is very observable even in Sorsogon, so skilled professional civil engineers are very much needed. Construction firms already opened job vacancies for foreign civil engineers just to sustain the lackage. But before a foreign civil engineer can practice professionally in the Philippines, these are the things they needed under the law RA 8981 or the Professional Regulation Commission Modernization Act of 2000. Number 1. The laws of the foreigner state or country allow the citizens of the Philippines to practice civil engineering on the same basis and grant the same privileges as those enjoyed by the subjects or citizens of such foreign state or country. It's like a give and take process between the two involved countries. Second is that it must be allowed under international law. Third is that they must be consultant to be engaged in foreign-funded, joint venture, or foreign-assisted projects of the government. Next is that they must be employees of Philippine or foreign private institutions to the law. Lastly, they must be engineers who were former citizens of the Philippines who had been registered and issued a certificate of registration and a professional ID to their naturalization and who, while in the country on a visit, sojourn, or a permanent residence, desire to practice their profession. The application of the law is, however, not automatic. Foreign civil engineers must still secure a certificate of registration or license or special permit from the Professional Regulation Commission. Agencies, organizations, or individuals, whether public or private, who secure the service of a foreign civil engineer are made responsible by law, or the RA 8981, for securing a special permit from the PRC and the Department of Labor and Employment pursuant to their respective rules.